Your Honour, may it please the Court, my name is Brady, initial JP, and I'm the counsel for the plaintiffs Mr and Mrs White. The counsel will ask the Court today to impose an interlocutory injunction to restrain the bank from taking possession of the plaintiff's home. The submissions below will outline a prima facie case is evident and the damages applied to the plaintiffs are an inadequate remedy. The counsel understands that the plaintiffs will need to show that damages at common law are an inadequate remedy and provide evidence that a serious question can be tried to protect the status quo of the parties after an injunction is applied. The balance of convenience can satisfy relief should be granted also is another factor to consider. Castlemaine Toys Limited and South Australia 1986 161 CLR 148. Justice Mason at 153 summarised these elements and stated the probability of the plaintiff being granted relief is upon the evidence found in the status quo. Further, the damage imposed on the plaintiffs would be an irreparable damage unless an injunction is imposed. Beecham Group Limited and Bristol Laboratories Proprietary Limited 1968 118 CLR 618 highlighted the court to consider the balance of injury. The question that the court asked was, how will the injunction benefit or disadvantage both parties? The case of Australian Broadcasting Corporation and Line Game Meats Proprietary Limited 2001 High Court case 63 at 16 and 17 decided if a plaintiff cannot provide evidence from the status quo, no prima facie case can be identified and has no legal right to restrain a party under an injunction. This was to be identified by using the status quo of the parties and the probability of inclusive relief after a final hearing. The counsel will rely on the following submissions to apply equities jurisdiction from the status quo, and the counsel will provide evidence from a prima facie case of the issues in unconscionability which led to an unfair bargain. Principles outlined in Machinsky and Dodds 1985-160 CLR 593, Justice Dean at 165 stated, equitable remedies are only available when warranted by established equitable principles. In addition to this, Justice French in the Australian Competition and Consumer Commission and C.G. Barbatus Proprietary Limited No. 2 2006 FCR 491 stated a party who has a legal right shall not be permitted to exercise that right if it amounts to unconscionable conduct. The general background of the plaintiff, Your Honour. Mr White is a retiree and has admitted to having a lower than average IQ and leaves all the finances to Mrs White, his wife. She has been recovering from a stroke and dealing with urgent family matters prior to the contract between the bank. Rob White, the plaintiff's son, did not disclose the correct information about the amount of the loan being $2 million, nor did he proceed to let them know about the duration of the loan. However, the bank proceeded to accept the plaintiffs as guarantors to the loan without any further documentation or reference to legal advice, and has amounted into the son now defaulting in that loan, and the claim wishes to claim the security under the contract. With reference to capacity, Your Honour, the counsel is aware that the lack of mental capacity to understand will not render a contract void with respect to the High Court decision of Gibbons and Wright 1954. However, held in equities jurisdiction for unconscionable dealing, Blomley and Ryan 1956 99 CLR 362 decided that a contract to be set aside for unconscionable dealing amounting to an unconscionable bargain. Justice Fulliger highlighted circumstances that a plaintiff may suffer a special disadvantage with reference to the plaintiff's sickness and illiteracy were noted by His Honour. In the case of Louth and Diprose 1992, found that emotional dependence could be a special disability that could be exploited by a defendant. The plaintiff can establish they held a great deal of trust and reliance in their son to ensure that they held an adequate information about the contract. And Mr White Jr.'s deceit could be evidence of exploiting that dependence and place the plaintiffs at a special disadvantage. Upon these elements, Your Honour, they could be satisfied for unconscionable conduct, and the counsel is aware that the onus must shift to the stronger party of the contract, which is the bank. The counsel for the plaintiffs are aware that there are evidentiary gaps pertaining to actual knowledge of the bank and the plaintiff's act or omission to seek legal advice. The case of Australian Competition and Consumer Commission and CG Barbados Holdings Proprietary Limited 2003-214 CLR found that a plaintiff had sought legal advice prior to the execution of the contract. For this reason, the defendant's conduct could not be found unconscionable. The plaintiffs in this current case, Your Honour, did not seek advice nor thought it was necessary because of the trust and reliance in their son. The case of Commonwealth Bank of Australia and Amadio 1983, Justice Dean stated that the appellant should have made proper inquiries into the parties and ensure they had fully understood the agreement. Counsel for the current plaintiffs argues that the bank may have known or ought to have known of a special disadvantage and should have made an inquiry, and this presumption is a serious question to be tried. In the above submissions for unconscionable conduct, Your Honour, the counsel submits the prima facie case to proceed with an interlocutory injunction. Principles outlined in the Australian Broadcasting Authority Corporation and O'Neill, which assured the courts not to elude the likelihood of the plaintiff's claim to succeed, but to find that there are sufficient reasons to preserve the status quo of the parties. And with reference of damages, Your Honour, in the case of Solomon and Innes and Carter and Landstrom 2017, Queensland Supreme Court Justice Lyons stated that damages of losing home are unique and inadequate. Based on a prima facie case already being established, it would be unnecessary to impose these type of damages if an injunction is not granted. Damages in the current case, Your Honour, involve the plaintiff losing their family home and could be considered inadequate and unique. The economic cogs of the bank can continue to proceed if an injunction is imposed. The bank is eligible to rebut the claims of the prima facie case made by the plaintiffs, and the bank's right to claim the security is still protected under an interlocutory injunction, providing that the prima facie case of unconscionability is rebutted and is shown to be conscious and fair. For the submissions above, Your Honour, the counsel asks the court to apply an interlocutory injunction and to preserve the status quo of the parties and restrain the bank from taking possession of the home until a prima facie case is rebutted in a further hearing. Your Honour, thank you.